the hearing in the appeals of Baker against Quantum Chosen Group?
Yesterday afternoon I got perhaps distracted from my central argument by a discussion about the knowledge of a reasonable employer, as my Lord Clerk put it. And we thought about that overnight, and we wondered whether a response to or an analysis of the knowledge of the reasonable employer might be by use of a rule of thumb, to use Lord Justice Newberger's expression, as he then was, such as this, that it might be for an employer to show why, in the absence of actual knowledge of the public documents, he or it did not have constructive knowledge, given that Noise and the Worker in the third edition, which your Lordships have in Core Volume 3, tab 11 at page 4, says that if the employer has workers who find it difficult to hear each other speak while they're at work in a noisy environment, then a noise survey should be carried out and that they should obtain specialist advice.
Sorry, what was that document you were referring to?
My Lord, that was Noise and the Worker, third edition, yes. Core Volume 3, tab 11, page 4.
Oh, what was the date of that?
1971, my Lord.
Yeah, thank you.
So, Lord, can I turn from a knowledge of a reasonable employer to the actual knowledge in this case? Your Lordships looked yesterday to see what the judge found about the knowledge of the second appellant. Can I then turn to the knowledge of the first appellant? The judge's, because this is an issue in the appeal, of course, the judge's finding is at judgment paragraph 56. That's Core Volume 2, tab 6, at paragraph 56. Sorry, paragraph 56 is one we looked at yesterday in relation to the second appellant. It was the knowledge of the EEC proposals in 1982. And when one cross-refers then to the first appellant to see what the knowledge of it was, that is dealt with in paragraphs 57 and following, and in paragraph 59, your Lordships will see reference to a report from Midland Insurance in 1983. Your Lordships don't need to know more about that than is found in paragraph 60, which says towards the bottom of the page, of the documents referred to, the first is a noise survey and accompanying documents done for Huthwaite Avenue by Midland Insurance in June 1983, claiming the same document. Mr. Watson, of the first appellants, had discussed the conclusions of it with Midland Insurance, as appears on the face of the document, though he said in evidence he couldn't remember it. Survey refers to the dBA, 90 dBA limit and suggests that all areas in the survey above 87 should be areas where air protection is worn until the noise is reduced by engineering methods. Number of areas identified as having noise over that level, proper training and instruction of staff advised, appended guide to preparing a noise control policy in which it suggested that any noise reduction program should aim at reducing noise to 84 dBA or less if practicable. And then picking it up at the bottom of that paragraph, Mr. Watson said, in evidence, he was aware of the EEC proposal in 1982 to reduce the exposure level to 85. He was aware of the existence of the debate about that proposal from discussions with insurers. It was viewed with some scepticism, I think. Coates was a large organisation. By the time they came on the scene, tension, if any, must have been focused on the EEC proposal that led to the 1989 regulations. There is therefore no evidence that anyone in Nottingham Manufacturing or its subsidiaries with which this case is concerned turned their mind towards the level of risk about possible harm below 90, except that Mr. Watson was aware after 1982 of a debate going on about what levels would ultimately be imposed. By the summer of 84, it was known that though the compulsory level would remain at 90, some measures, possibly audiometry, would be imposed at 85. The 1983 Midland Insurance document is an important document with its plain implication that the 90 dBA code of practice level didn't provide protection to everyone, that our noise conservation policy should do better, but it does not provide the information that means that management at Nottingham Manufacturing were in a position to acknowledge and understanding that set them apart from what I take to be the understanding of the great majority of employers that 90 was the official limit that had to be worked to. Don't think it's shown that Nottingham Manufacturing had a greater than average degree of knowledge. As your Lordship know, we attacked that conclusion of the judge on the basis of the evidence that he sets out there, and the Court of Appeal dealt with it at tab 3 of this bundle at paragraph 109. At 109, as a fallback submission, Hendy argued that the judge had been wrong to reach a different conclusion in respect of quantum. There was evidence that it was aware of the first draft directive, and Hendy submitted that given that knowledge, it was irrational to say that because the group was smaller than Pretty Polly or Courtaulds and operated as individual companies without the benefit of central advice on health and safety issues, they should be treated differently from the other two employers. I accept that submission, hold that if it were to become material, Quantum would have been in breach of its common law duty at the same date as Courtaulds. And we respectfully seek to uphold that decision of the Court of Appeal on the basis of the evidence that the judge had before him.
Just tell me what the evidence, how the evidence bore on quantum, because Nottingham Manufacturing Company only merged with Vantona Viella in 1985, and the resulting entity only became a subsidiary of Coates Viella in 1986. And Mrs. Baker wasn't employed by Nottingham Manufacturing, or I see. She was employed by a subsidiary of Nottingham Manufacturing. Yes.
That's right, my Lord. The names changed, but Mr. Watson, who had the knowledge in 1983, was, I think, in the same company or the same group of companies. So his knowledge was material. Obviously, he wouldn't have. I'm not sure whether it explains here what his position was. Just miss that for a moment. 59, I'm grateful to Mr. Nolan. Mr. Huckle reminds me that it's not been suggested that Quantum didn't have the knowledge that Mr. Watson had.
So what does it boil down to? It boils down to the Midland Insurance survey
and the 1982 debate.
Plus the knowledge of the Commission proposal.
That's it, my Lord. It's really what His Honour has set out in paragraph 61, summarising what comes in the paragraph previously. We say there's no real difference between them and Courtaulds, A2 that we looked at yesterday. Lords, I should then look at the knowledge of the third appellant. That's dealt with at paragraph 63 onwards. And your Lordship will see that in paragraph 63, that Pretty Polly served a number of witness statements but in the event called no factual evidence, the documents disclosed were the Wilson Committee, Noise in the Worker, Code of Practice, the Gene Stone Hatra report, and some of the HSE consultative documents. The internal documents included a guide to preparing a new noise control policy for Midland Insurance, which was the same guide which had appeared in relation to quantum, undated but probably late 1970s or early 1980s, in which it said exposure to 90 over a long period, possibility of damage to hearing, so adequate steps should be taken to prevent this. Also, a noise reduction programme should aim to reducing noise to 84 or less if practicable. That's identical. And a commercial union risk management paper from 1977 saying research has shown few industrial workers suffer hearing loss if the intensity and duration is controlled to allow maximum of 90, and later exposure standard of 90 is based on the prediction that not more than 1% of those exposed over 30 years will suffer social handicap as a result. Levels should be reduced wherever possible, 90 regarded ceiling rather than a safe level. There's a memorandum from the Work Study Department about 1982 written by Mr. Butler, later became production manager, wide circulation, 90 was the maximum level. Noise at that level involved accepting a certain risk of hearing damage. If we as a company feel we require a zero risk of hearing damage for our employers, then no person should be exposed to noise level more than 80 for an 8-hour day. Followed percentage risk of hearing damage showed that at 0% at 80 and at 85 1, 3, 5, 6, 7, 8, 9 and 10% for 5, 10, 15, 20 and so on years of exposure respectively. Percentages at 90 for the same years they're set out. Those figures were taken from the international standard ISO 1999. 1985 assessment of occupational noise by Mr. Butler, and the quotation is or just above the quotation, straightening machines at all machinery areas in the company were in excess of 85. Even at this level, we're accepting a certain risk of damage for our employees. For zero risk of hearing damage is required, then no employee should be exposed to noise of above 80 for more than 8 hours a day. Then there's documents about the noise at work regulations, and in 66, no evidence that anyone at Pretty Polly turned their mind towards any evaluation of risk below 90 before 1982. It's not really likely they did so, plain from Butler's documents. By that year, he had done so. Indeed, unlikely that a company of that size, where there have been some collection of materials and where they cannot have been unaware of the EEC proposals and the very public debate that followed, couldn't have known that there was a real case to be made that exposure below 90 could cause levels of hearing damage that should be guarded against, therefore put actual awareness of the nature of the real risk below 90, as with portholes, arisen by the beginning of 1983. So it's in the light of that, as well as the portholes findings, that we say that the judge, having set out the evidence that persuaded him in relation to quantum, was clearly wrong, and the Court of Appeal were right. So far as the intervener is concerned, the intervener didn't have a noise problem because, I won't take you through it, but it's judgment paragraph 222. It's clear that the noise level there was around the 80 mark. So, my lords, in relation to knowledge, we say this is not a lone furrow case. The employers in these cases knew of the risk below 90, and the employers in the cases that we looked at yesterday, Crocker and Ford, Howells, British Leyland, Harrison, British Railways Board, knew of the risk below 90. There was evidence also adduced before His Honour in relation to a company called Metal Box Company Limited. Mr. Cooper from Courtaulds knew about that. There's evidence about that. Professor Lutman was the advisor to Metal Box. He gave evidence about it as well, and that evidence, to put it in a sentence, showed that from the early 1970s, Metal Box were aware of a risk below 90 and were taking steps to deal with it. Lords, the appellants, of course, put great emphasis on the code of practice, which they say was the only official guidance, and that they shouldn't be required to look behind it. Your Lordships looked at the code of practice yesterday. I don't propose to go there again, but can I pick up one point from the Court of Appeal judgment? It's the Court of Appeal judgment at paragraph 49, that's at tab 3, which is criticised by Mr. Beloff and I think by others as well. Lady Justice Smith says there, more important even than that is the uncertainty about the effect of the judge's holding in paragraph 87. When I read the judgment, I thought that the holding, paragraph 87, meant that for average employers the date of knowledge was 1987 by reference to the publication of a consultative document on the 1986 directive. Later, from his holding that there was no liability in respect of Mrs. Baker, who was provided with ear protectors in 1989, I inferred that he must have given her employers, who he said had no special knowledge, 2 years in which to react. However, Mr. Owing, who appeared from Quantum, submitted that the judge had held that there was no liability throughout the whole of the 80s and that liabilities had only bitten when the noise at work regulations came into force on the 1st of January 1990. It's unfortunate this important aspect of the judgment should be left unclear. However, I detect no sign of the judge making a holding by reference to the 1989 regulations, and I conclude that he intended to hold that for average employers, which included Quantum and Guy Warwick, the date of knowledge was 87, and the date for action, liability in the absence of action was 89. Deal with that appeal on that basis. Now, that critical paragraph, which the appellants say the Court of Appeal got wrong, all turns on paragraph 87 in the judgment. And paragraph 87, we looked at parts of it yesterday about the judge's recognition that the public documents showed risk below 90. Can I pick it up on the facing page above paragraph 88 and pick it up at the line that begins 6 lines down with the word employees full stop. Reading on from there, to put it in the context of Mr. Justice Swanwick's judgment, applying the 90 LEPD, it's the highest acceptable level, was, I think, meeting the standards of the reasonable and prudent employer during the 1970s and 80s. Certainly until the time when the terms of the 1986 directive became generally known in the consultative document of 1987. I accept that this means that employers were not bound, and then he goes on to other matters. Now the question is, was the judge meaning that employers were acting according to the code of practice right through to 1st of January 1990, or was he saying that guidance came to an end with the directive? And in our respectful submission, he plainly means 1987 as the end point. That's what he says in terms. And that is fortified by reference to earlier paragraphs, if your Lordship, and later paragraphs. If your Lordships look at paragraph 39 in the judgment, there he explains the consultation process back in 1982. The Lordships have obviously seen this before, but I'll just pick up a couple of sentences. Just above halfway through paragraph 39, there's a line that begins with a sentence. On the one side, CBI and employers sought to hold 90, on the other, some unions supported the Commission. Others still argued for the 80 DVA LEPD, and it was captured in Hansard in 1983, withdrawn in 1984. It was replaced by less stringent proposals, led to the Noise at Work Directive of 12th May 1986. Exposure limit was 90. But where the exposure is likely to exceed 85, ear protectors made available together with information where relevant training, wearing of hearing protection, opportunity of medical tests, resulting legislation brought into force by the 1st of January. Recitals of the directive make clear the Commission had it in mind that the directive was an interim measure and it was likely to return to the subject to achieve lower noise levels still, and there's a quotation from it. So his lordship had in mind the significance of the EEC debate in 1982 and 1987, and going back to paragraph 87, that's followed by paragraph 88, where he talks about greater than average knowledge to inform steps that individual employers should have taken at an earlier time than the late 1980s. Not the 1st of January 1990. At first sight, it's not attractive. Those who have a safety department, medical officers take the matter of noise seriously should be worse off than those who wallow in relative ignorance. Separate point, of course, is an inevitable consequence of a test that depends on what an individual employer understood. On that basis, I have found that by the beginning of 83, management, both Courtaulds and Pretty Polly, had a sufficient understanding of the risk of hearing below 90 to require them to take action. Both say they did so, and so on. And then it goes on to say, at the end, I'd say they were in breach of their duty to employees who suffered damage through exposure at 85 and above without having the opportunity of using hearing protection for the beginning of 1985. So it's a reference back to Courtaulds and Pretty Polly, whose actual knowledge was dependent, as he found, on knowledge of the debate in 1982 to 3. And therefore, we say that fortifies our submission that he was saying in paragraph 87 that the knowledge there ran out, as it were, or the reliance on the code ran out with the knowledge that was acquired from the debate about the 1986 directive, which became generally known in the consultative document of 1987.
Can I just ask you, you read us a moment ago in relation to Pretty Polly, some memoranda which suggested that if we as a company feel we require a zero risk of hearing damage, then no person should be exposed to a noise level of more than 80 dBA. Even at 85, we're accepting a certain risk of damage for our employees. What would be your stance if the present case depended upon exposure to noise between 80 and 85, and in particular, what would be your stance after, for example, before the 1989 regulations came in and after they came in?
In relation to risks below 85, my lord?
Yes, should bearing in mind that sort of statement, I mean, would you say that that meant also that that was at common law it was unacceptable to follow the approach indicated by, for example, the regulations of 1989?
Lord, my lords, we would say that. I can see that we've got a difficulty below 85 because of the increasingly small risk to which the workforce was subjected, and at common law that could pose as a problem. But certainly, since we say that from 85 to 90, the common law does provide a remedy regardless of the 1989 regulations, then the logic must be that it would equally apply theoretically below 85 as well. But as your lordships appreciate, we've not pursued that, and his lordship found that was only a minimal risk, which we haven't sought to finding which we haven't sought to disturb.
But logically, surely, I know one mustn't look at it with hindsight, but if any single workman suffered hearing damage as the result of the noise levels in a factory, am I right in thinking on your argument there is a breach of Section 29?
Subject to the defence of reasonable practicability, we would say yes. Lord, just going back to the code of practice, just some additional points. We make the point that, of course, the code of practice doesn't stand alone here. Noise and the worker was specifically official guidance to employers, and the last edition of Noise and the Worker in 1971 mentions the coming code of practice in its text, but nevertheless it remained extant. And in our respectful submissions, the appellants cannot ignore the public documents, the British Standard and the International Standard. They too were official guidance, or they were at least to expert advisors and to insurers who should have assisted employers. Just a word about British standards. We've dealt with this in our written case, and I won't develop what we say there, but it's paragraphs 152 to 160, and then rather repetitively, I regret, from 170 to 191. But there is some authority in relation to British standards in different contexts, and I'll just show your lordships one case, which is Doherty and Rugby Cement, which is in the Authorities Volume 3 at tab 38. Okay. Rugby Joinery, sorry. And there, Lady Justice Hale, as she then is dealing with a vibration white finger case and a forerunner of a British standard called DD43, that's Draft for Development number 43. And at paragraph 47, which is on page 1286, Ladyship says, nothing in those reports would have led the claimants to believe that the defendants were contending for a date.
I do beg your pardon, Mr. Henry. What paragraph are you looking at?
I'm so sorry, Lord. It's paragraph 47.
Thank you.
Nothing in those reports would have led the claimants to believe that the defendants were contending for a date of knowledge later than the mid-1970s. This is scarcely surprising, as British Standard Draft for Development 43 of 1975 is the sort of official publication which large employers are routinely expected to scan to see whether it contains advice which might affect them. It was not an obscure article in some medical or scientific journal, but official advice. Had there been any suggestion of a later date of knowledge, both experts might have produced a more thorough survey of the literature. That such literature exists is within the knowledge of any, and so on. So it's a comment on the British Standard, and in the vibration white finger cases, this draft for development of 1973, a draft of a British Standard by itself is held to sufficient to found liability. And can I give your lordships the references to those other cases? Brown and Chorus, which is Authorities Volume 2, tab 19, paragraphs 13, 21 and 29. Brooks and South Yorkshire, which is Authorities Volume 2, tab 18, paragraphs 21 and 23. In that case, the court found that the draft for development had not been sufficiently disseminated for that particular employer, but found that the British Standard was in a different category. And Armstrong and British Coal number 2 in the Court of Appeal in 1998, which is now in, I think I'm right in saying, in the third appellant's supplementary bundle at tab 2. And Lord Justice, Judge as he then was, deals with this at pages 7 to 9 and 16.
I don't know what sort of standards they were. Some British standards do set standards, don't they, for the production of for a particular material or piece of equipment.
Yes, Lord.
This deliberately doesn't, does it? It says on page 1109 in tab 15 of bundle 3, determination of a maximum tolerable noise exposure is outside the scope of this standard. It involves consideration of risk in relation to other factors. For occupational noise exposure, such a limit is specified in the Department of Employment 1972 Code of Practice for reducing exposure of employed persons to noise. So, I mean, it might be said that the employer perusing this wouldn't do the exercise you did yesterday, which is construe the tables in detail, but he would assume that the Code of Practice was appropriate for occupational noise exposure.
Well, save that the DD 43 did set out tables in much the same form, the incident of
Sorry, DD 43?
DD 40,
Oh,
the draft
yes.
of development,
Yes,
my
thank you.
Lord, in VWF cases,
Yes.
sets out the incidence or the predicted incidence of vibration white finger for tools of particular vibrating frequency used for particular periods over so many years. So in that sense, it is comparable to the British standard and the international standard in the instant case.
I think we were, I'm trying to find it now, but there was a passage in Mr. Kent's case, I think, where he referred to the fact that there was quite a lot of evidence, expert evidence, before the judge about the British standard and the extent to which, if any, the standard would in fact be used according to the evidence of those various witnesses. And according, I can't find the reference at the moment, but Mr. Kent, I think, says that the evidence was that in the real world, the standard, the exercise that you performed for us yesterday would not have been done, and in the real world, the standard really wouldn't have been used in the way that you're contending for.
No,
Is that wrong?
my Lord, we say that is wrong, and the point is that the question that should have been asked was not asked. Lord, if your lordships look at the judgment, I think it's paragraph 47, 46 rather, which is headed the general approach to noise in industry. In the last half of that paragraph on the following page, sorry, let me just identify who the speaker is. I'll pick it up at the bottom of the first page on which 46 appears. To Mr. Bramer, the guidance in noise and the worker and the 1972 guidelines provided clear and consistent recommendation to employers as to how they ought to deal with noise in the workplace. The result was that in his practice, his variable advice till the late 1980s was relevant level daily personal noise exposure of 90. This approach, he said, was standard during the period up to 1989 amongst noise professionals and taught at training courses. Mid-1980s, when it appeared that EEC regulation would involve first action level 85, his advice changed to reflect that. He was not aware of the tables before the 1980s when he found that they were being used by medical experts writing reports for the purpose of deafness claims. Never come across them being used in any part of industry. In evidence, Mr. Bramer said that he gave advice to employers in terms of complying with the 1972 code. He was speaking to the 90 dBA level, as were all his colleagues. He agreed that the advice would be to answer the question, tell us how to comply with the legislation and the code of practice, rather than tell me how to avoid reasonable, foreseeable risk to my workforce. He would have recommended 80 as the cut-off point, but would also have said that doesn't actually stop some more susceptible people from having small noise-induced hearing loss. If asked about risk, he would have had some difficulty and regarded the question as more one for medical people. So the reason why the experts were relying on 90 was that the question that was being posed to them was, how do I comply with the legislation and the code? Whereas we say the question that the reasonable employer should have posed is, tell me how to avoid reasonably foreseeable risk to my workforce. And that would have produced the answer, I need to consult the tables.
But in the real world, the Code of Practice is produced under the aegis of the Department of Employment with experts from industry, with experts from trade union side, and with independent scientists. And it is issued in order to avoid people having to invent the wheel, isn't it, and do all the work for themselves. So long as it's out there, isn't it something which is an acceptable standard to follow, or not?
My Lord, if it had said nothing about any risk below 90, that might be a tenable argument for the appellants. But it didn't. It recognised that there was risk below that, and everybody knew that the setting of 90 was a controversial one. And that meant that it was known that there was risk below that. And I don't deny that it's relevant to take that into the code into account, clearly.
But can't one reasonably infer from the fact that the Code of Practice sets the level at 90, and the fact that it does, as you rightly say, it does refer to the possibility of risk at a lower level, but it in fairly muted terms can't be guaranteed that if the risk of injury below 90 had been regarded as a real significant risk, then surely the standard would have been set at lower than 90, or at the very least, the scale of that risk, the gravity of that risk would have been flagged up in much more strong terms than in fact it was.
Well, the gravity of the risk remains as it was revealed in the tables that we looked at yesterday in the early 1970s. Nothing has changed. What's happened is that the guidance given by the European directive has brought the level down to 80. So there's no argument that the risk of injury, the incidence and the gravity is much less below 85 than it is below 90, than it is below 100. Nobody could conceivably deny that. And what the code was doing was saying, in the first place, 90 is the maximum level, but there are risks below that. We say reasonable employer, knowing that there were risks below that, should have ascertained what they were, and the means were there in order to carry that out. If he'd taken the advice that Noyes and the worker told him to take and asked the question, is this going to adversely affect some of my workers? Only one answer could have come back. Yes, it is.
I think that's what Judge English says in paragraph 87, isn't it?
Indeed, my lord.
And your point is that a properly informed employer would have known that, as you put it yesterday, if you expose workers to 85 dBA and above over a prolonged period, then a certain percentage of them are going to suffer hearing loss.
Yes.
And that's why it's pertinent and apposite to ask the question, how do you avoid risk to the hearing loss, to the hearing of my employers, rather than to say, how do I comply with the published standards?
Exactly so, my lord. That's our case.
Could you just give me the cross-reference to noise in the worker?
So sorry, Lord.
Could you just give me the cross-reference in the bundle, the reference
Yes,
in
it's
bundle?
core bundle 3.
Thank you.
And the third edition is tab 13, my lord.
Thank you.
Oh, sorry, forgive me. No, it's tab 11.
Third edition is Core Bundle 3 at tab 11, is that right?
It is, my lord, yes. Sorry, did I say something different? Forgive me.
No, I don't think you did. No, I was just looking at my own note to make sure I got it right.
The reality is, I mean, your case involves this, and statements like those in Norris, to the effect that there is a standard which generally applies and can be taken as a guideline, are in fact themselves misleading. This is a case where every case that comes before the court will be found to be an exception, won't it?
Well, perhaps not every case, but some cases certainly, yes.
I mean, courts regularly say as a general rule this, but there may be
Yes.
other cases, and then one finds that there are almost every other case is an exception.
That may be so, my lord, yes. Yes.
Mr. Hendy, while it's in my mind, and I don't want to take you out of your course, speaking for myself, I would like to know, in perhaps summary form, what you say it is that each appellant should have done to comply with what you postulate is the duty under Section 29 and the duty under common law, what each appellant should have done and when that should have been done.
Well, Lord, although we're not appealing the Court of Appeal's findings of dates, our case has always been that from the 1960s, or at least from the publication of the British Standard in 1975, which allowed the calculation of risk, the employer should have first of all ascertained which areas of the factory workers were exposed to greater than 85 dBA LEPD, and in those areas should then have conducted audiometry to see, because periodic audiometry would allow the employer to know which, if any, particularly susceptible employees there were, and should then have offered, with the benefit of information, training and encouragement, should then have offered earplugs, or ear defenders, I should say.
That wouldn't, in fact, make the premises safe on your argument, would it?
No, it would make the premises safe for any person working there, however. It would make it safe for the particular workers.
Well, only if they wore the ear defenders.
Well, absolutely, if they would have to have responded to the encouragement.
I'm not sure. You see, I'm not quite sure where that takes us. If I understand your argument correctly, the premises are unsafe.
Yes.
They would only be made safe if the people working there wore ear protectors.
That's correct.
But is offering enough?
But the employer's only to do that which is reasonably practicable. I can see there may be an argument about whether it was reasonably practicable to compel the workers on pain of dismissal to wear the ear defenders, but certainly we don't need to go that far. We say it was reasonably practicable to give the training, encouragement and warnings and provision of earplugs, and we know that in these cases, those who were offered them did use them from the point that they became available.
Yeah, I follow that. So if I understand you correctly, the final breach, if I may put it like that, or the breach, is the failure to instruct and offer ear protection.
Yes.
And that is what the directive ultimately provided for, is that right? I don't mean ultimately, I mean in 1970.
Yes, indeed. Yes.
Sorry, 1990.
86, yes, yes. Yes, and then ultimately became stricter still. Yes.
But I mean, he wouldn't be at all safe on your approach to take 85 dBA if he'd been able to foretell what His Honour Judge Inglis was going to decide some 20 years or so later. He might have foretold that it was going to be described as minimal, but actually looking at these tables, it certainly wouldn't be minimal. I mean, if I compare someone with an 83 or an 84 dBA exposure for 30 or 40 years, and then I use table 4 to find the right figures there, and then I subtract what is supposed to be a minimal exposure of 80 from that, I still get, on my calculations, 3 or 4% of the population, which so I mean the reality is putting oneself in the position of your reasonable employer, he would have to actually from the early 60s or mid 70s guard against anything over 80.
Yes, Lord, and that's what the insurers were saying. If you want to have zero risk, you protect from 80. Those are the documents that His Honour had in front of him.
But was there an obligation to provide zero risk? I mean, I'm not clear how far you're putting your case.
My Lord, we accept the notion of a material risk, and that's why we accept the cut-off point at 85. We appreciate that the argument could be made, and indeed we made it before His Honour Judge Inglis, that there was a material risk, as my Lord Mance indicates on the tables, from 80 up to 85. But we didn't argue that terribly forcefully, and we now accept what the way His Honour Judge Inglis put it, accepting that it was a minimal risk below 85, and we say that there's no obligation in relation to something which is not a material risk to guard against. I wouldn't want to...
A minimal risk is a risk which is not a material risk, is it?
I'm so sorry?
I mean, in your
yes,
dictionary,
we're
minimal risk is something that is not a material risk.
We're equating the two for the sake of the
You said that you asserted that it was a material risk, but the judge rejected that in relation to 80 to 85.
Yes. We did say...
Then you haven't challenged that.
We haven't challenged
Whether
that.
he was right or wrong about that, therefore, is immaterial in this litigation.
Maybe other cases that will be challenged, but not in this case.
It is a 3 or 4% risk if you take 84 and 40 years.
Perhaps the judge was wrong. So I suppose you have to make these forensic decisions in the course of litigation.
Well, absolutely, my lord. Yes. Can I just take a moment?
Yeah.
Yes. Well, Mr. Huckle points out that on the facts of this appeal, on behalf of Mrs. Baker, of course, we weren't in a position to challenge it. But your lordships are looking for a wider logic. I appreciate that.
You go for material risk, and you would reject, presumably, acceptable risk.
Yes.
Why?
Well, if acceptable risk means a material risk or a risk that is substantial with not insubstantial, then I suppose that I'm quibbling over language. It means the same thing.
Well, the Court of Appeal roundly rejected acceptable risk in relation to Section 29, but as I read their decision, thought that it was material or relevant when it came to the common law. Do you support that distinction, do you?
Lord, it's not really necessary for us to make that distinction or indeed to support it, because Mrs. Baker was subjected to 86 decibels and above. And I wouldn't want to limit those who might wish to argue below 85. We do accept in the circumstances of this case that if one wanted to say that the risk below 85, because of its incidence and because of the severity likely to occur, was an acceptable risk, then that's perhaps no distinction between that and a material risk, which we say needn't be guarded against. But I don't want to be drawn into making a concession that might affect others, of course. But
I only put it to you because Lady Justice Smith made that very distinction and made it rather forcefully.
Yes, because under Section 29, safe is, as we say, safe. There is no acceptable risk in the first part of the Section 29 equation. Lords, can I say something about the factory inspectorate? We know that the factory inspectorate concentrated their advice.
I mean, sorry, just going back on my lord's point, the word acceptable comes out of the code, doesn't it?
Yes.
And I mean, why can't an employer say, well, or an occupier, I should say, well, if the industry has a standard which is agreed to be acceptable, well, why isn't that enough? After all, it's all in the context of the necessity that employees should be safe, or at any rate reasonably safe.
Yes. Well, I think
there's no such thing as absolute safety, as Lord Denning pointed out in one of those cases, is there?
No, because even at 80, if you're exposed if you start work young enough and work long enough, you're going to, there's a likelihood of suffering loss, certainly in a minority, as my Lord.
But are you really saying that actually the trouble with the code is that they declared something to be acceptable, which was actually unlawful?
Yes, well, indeed, Lord, and they pointed out that there were risks below that level, so it was known that people were likely to suffer injury in consequence. We say that can't be acceptable.
Do you accept that the factory inspectorate or the HSE or whoever it is who's responsible for prosecuting under this legislation, that they, during the material time that we're concerned with, that they used the code as the yardstick for purposes of prosecution?
Well, I'm not sure that they did ever prosecute, but certainly they used the code as a yardstick.
They used it as the yardstick.
Without a doubt, they used the 90 decibel level, indeed. And the reason for that is clear, because they were concentrating on the higher level, because that covered, that was where most damage was likely to occur.
Did they ever prosecute anybody?
Well, not so far as we've been able to find out. And they certainly, there doesn't seem to be any evidence that they prosecuted after the regulations came in, when employers failed to reduce from 90 to 85.
Perhaps they thought noise wasn't covered by the statute.
Well,
perhaps they didn't think.
Yes.
Well, the regulations would themselves be a breach would be a statutory offence, wouldn't it, under Section 76?
Yes.
So
yes.
They could once the regulations came.
They could. But I mean, the reality is that they have finite resources and they concentrate where their effort is greatest. And even at 90, it's unlikely that people are being made deaf, let alone losing lives or being disabled through injury. So clearly the factory inspectorate is going to focus on the most serious risks to workers.
But that's the same philosophy as underlies the code of practice insofar as it accepts a level of risk. The philosophy is that society generally, and no doubt some employers who have noisier and less noisy factories, should concentrate on the really damaging levels, and below a certain level it was acceptable not to.
Well, I shouldn't say society generally, because of course we know from His Honour's judgments that there was great debate about this, and those representing the workers, the trade unions and so on, were always arguing for lower levels. Employers were arguing for higher levels, and it was a political compromise at the end of the day, as have been the later levels.
That's how standards of acceptable behaviour are set. Yes,
indeed.
I mean, there is a certain irony, as the judge pointed out, about the fact that those who actually said, well, why don't we be even more protective, are the ones who answer.
Well, that's same, Lord. It is ironic, but nevertheless, the fact that some employers were regarding this is an important feature of the case. That some employers did regard the risk as something that they were duty-bound to do something about.
Or at least that they did something about.
Well, they thought they ought to do something about whether they did.
They
enough,
thought it desirable, at least.
Yes. Lords, the reason for the concentration of resources is set out in the judgment at paragraph 35. Sorry, 36. And there's an extract from Framing Noise Legislation there, paragraph 19, which I think we looked at yesterday. But whatever the factory inspector's advice might have been, we say that didn't excuse the employer from asking the right questions, and I've shown your lordships paragraph 46 and 87 of the judgment. Lords, I've taken too long to get to where I am now, which is to start on section 29. Some of this, of course, I have dealt with by the way. But can I begin with Mr. Purchase's novel point introduced only yesterday, which is that there's a distinction between the employer and the occupier under the Factories Act of 1961. I think we need the Factories Act before us. It's volume 10 at tab 13. Well, the obligation, as he points out, is on the occupier or the owner. That's section 133. I'm sorry, it's not.
155.
155.
155, I'm obliged. But it appears to us that the occupier is treated as synonymous with the employer, and indeed it's hard to see how an employer of workers in a factory could be regarded as other than the occupier. Occupier is distinguished from owner. Owner is defined in the definitions section, but not occupier. But if one looks at some of the sections here, one sees that the occupier is treated as the owner. For example, if you look at section 86, Mr. Purchase's argument was that the occupier, as opposed to the owner, is not going to know who is employed or for how long or under what circumstances.
As opposed to the employer, do you mean? Not
Sorry.
the owner. You're
Yes.
comparing the occupier and the employer.
Indeed, I'm sorry, that's what I meant, indeed. But if you look at section 86, my lords, you see that there's provisions for meals and rest for every woman or young person employed in a factory, which has to conform to certain standards. So clearly it's assumed that the occupier knows which of the workforce it falls into the category of women and young persons. And at section 89, in relation to women and young persons, the occupier is taken to know how many hours overtime in any calendar year or in any week are taking place. In sections 87, the weekly hours of young persons is specified. And if your lordships look at section 100, women and young persons are provided for not more than 5 days a week, not more than 10 hours a day, which can be extended to 12 hours. Well, clearly it's only the employer that's going to know that sort of thing, and that's in the sections that follow. One only has to look down the descriptions in the margins to see that this is material that only the employer could possibly know.
Well, if you take section 100, subsection 2, at least assumes that it's the occupier who's going to employ people.
Indeed, my lord. Absolutely. And there are other expressions that convey the same thing as well. If one looks at section 119, power of inspectors to serve notices and so on. If one picks it up in the last half of that section, picking up, let us say, with the words "more than 7 days after the service of this notice," close bracket, and the occupier shall not continue after that period to employ the young person.
Does this really affect the point, which is that this, indeed it might be said to underline it, that what this statute is concerned with is the employer qua occupier?
Well, it's the employer as the person that controls the factory to which the Act applies. This is all about the safety provisions that apply in a factory and not to other workplaces, although the Factories Act was, of course, extended to other work places. Of course, we draw attention also to to sections 133, which deals with homework and begins in the case of persons employed in such classes of work and so on. The occupier of every factory and every contractor employed by any such occupier shall keep various records. And 135, in every textile factory, the occupier shall, for the purpose of enabling each person employed who's paid by the piece, keep certain records. So we say that the occupier is the employer is the occupier.
Well, the occupier may not be the employer, may he?
We can't, for the moment, think of a situation where the occupier of a factory wouldn't be the employer, say for subcontractors.
One could think of all kinds of legal structures which would achieve that.
Yeah.
Was there a report that led to this Act?
I'm so sorry, Lord.
Was there a committee or a law reform committee? Was there a Robins-type committee which led to this Act?
Oh, my Lord, it goes back into the 19th century. There have been many.
So it had always been the occupier, ever since.
My Lord, yes, I think it had always been the occupier. I can't say that we've done much research, having only met the point yesterday, but.
Maybe it assumes, not unreasonably, that if you are in fact employing people and carrying on a business there, in some sense or other, you must be the occupier.
Yes, yes, my lord. One can see immediately that their window cleaners might be brought on who are employed by somebody else,
Yes.
but
And more
Yes.
sophisticated structures, no doubt, today.
yes.
Well, what is the position about window cleaners? They're presumably not caught by this, qua employers. Their employers are not caught by this legislation.
My lord, there's lines of authorities about this which are lurking below the surface of my consciousness at the moment, Lord. I'd rather not answer
Well,
that
it'd
one.
have to be the occupier to be caught by.
Yeah. Lords, coming to the question of the proper construction of section 29, we accept, as Mr. Purchase in his written case sets out at paragraph 17 with a citation of authority, the need for a historical context and a holistic approach. But the historical context of the Factories Act is rather particular. My Lords, in our written submissions, if your Lordships have them, at paragraphs 32 to 37, we set out some extracts of the Robins Committee, which your Lordships have in, I think it's volume 12 now, at divider 17, the full passages. The Lordships looked at some later passages, these are earlier ones, which I appreciate your Lordships have read this before, but it's as Lord Robins put it, a remarkably piecemeal fashion that the industrial safety legislation has come about. And then there's a quotation from by Lord Robins of Sidney Webb, which is a passage which in our submission encapsulates the history of this legislation. There were hundreds of pieces of legislation and regulations and so on. They were piecemeal, they were overlapping, there were areas where they didn't go at all. There were areas which were covered by several pieces of legislation. Lords, I know it's the one thing that an advocate shouldn't do is to refer to something that he was originally the author of, but we do refer there to Monkman's 13th edition, which is in our supplementary bundle, I think. Am I right?
It says it's in volume 11, tab 22 in the margin. Was that the new edition?
Volume 11, yes, Lord, I think that's it. Yes, my Lord, this, should your Lordships need to go to it, in the absence of any other better textbook, better written, better researched, I humbly put it before your Lordships as a brief exposition of the way in which the safety legislation came about, and your Lordships will see there that which fell from Lord Robins and from Sidney Webb is amply justified. It's a mishmash of pieces of law, and we respectfully repeat what was said in paragraph 1.53 in that recitation, that even after the Robins report and even after the Health and Safety at Work Act, there did not come about a comprehensive and orderly set of revised provisions, and it wasn't really until the 1990s that some order was brought to this legislation. Now, Lords, the relevance of that is that when one's seeking to ascertain what the policy of Parliament was in introducing a section such as the amendment to section, or the last part of section 29 of the Factories Act, one has to bear in mind that they were dealing with legislation that was a complete piecemeal mishmash. And therefore, it shouldn't be assumed that they had anything particular in mind beyond normal, ordinary meaning of the word safe, and that they wanted to cover all eventualities. And the restrictive in construction which my learned friends seek to put on section 29, or the material words of it, in our submission simply cannot be justified having regard to the history of this legislation. They were looking for a broad belt and braces to make sure that the places at which workers had to work were made and kept safe. As simple as that. Lords, my learned friends advance the argument that where there's a general provision, that should be overtaken by any specific provision, but in fact, it's clear that the courts have not treated section 29 like that, or indeed other sections of the legislation like that. So, for example, in Ross and Associated Portland Cement, which is authorities, I have to ask your lordship to look it up, but it's authorities volume 6 at tab 101, and Wigley and British Vinegars, which is authorities volume 7 at tab 121. Both of those cases involve ladders, and yet section 28 deals, section 28 deals with ladders specifically, and yet section 29 was also applied in those cases.
Sorry, section 28.
28.5 says that all ladders should be soundly
you.
constructed and properly maintained. So section 28 and 29 can go together, as they were held to apply in those House of Lords cases. And in British Railways Borden Liptrot, which is in the respondent's further supplementary bundle, the green bundle, at tab 3, it was held that a crane, to which section 27 applied, was also subject to section 14, which is the dangerous machinery provision. And then a case at first instance, the last of the cases I'm going to cite in this connection, Davies and Massey Ferguson, which is authorities vol 3, tab 37, which is a chap who fell over at the foot of a flight of stairs. Judge held that was breach of section 5, the lighting provision, although it wasn't necessary to decide, having found on section 5, he would also hold that section 29 applied. So that the argument that the appellants put forward, that where there's a general provision it's limited by specific provisions, and if there's no specific provision then it's limited because there's a power to make regulations to cover specific points, in our submission simply cannot hold water. And indeed the effect of that submission is that section 29 has got virtually no application at all.
Well, you could in a way turn the argument round and say, well, if it's right, then it's got to cover something different from preceding sections. And noise is one of the things that it covers.
Well,
Yes, one could say that, my Lord. But we respectfully submit that what Parliament meant was safe for the person working at the place of work. Learned friends drew attention to, or put the case about always speaking, and drew your Lordship's attention to the case of Birmingham City Council and Oakley, which is Authorities Volume 1, tab 14. And my Lord, I think Mr. Beloff read to your Lordships a passage at 631, with which we do not, of course, disagree. But can we draw attention in the passage that Mr. Beloff referred to? It's tab 14 at page 631 in Lord Hoffman's speech, at letter F, after the reference to the Crown against Ireland. He says, I quite agree that when a statute employs a concept which may change in content with advancing knowledge, technology or social standards, it should be interpreted as it would be currently understood. The content may change, but the concept remains the same. And he contrasts that at letter H. Doctrine doesn't mean one can construe the language of an old statute to mean something conceptually different from what the contemporary evidence shows that Parliament must have intended. Well, with a word like safe, or keeping a place safe for anyone working there, the concept, in our respectful submission, hasn't changed at all.
The argument against you is that it's not necessarily a very natural meaning to find a room where, or a place where work is going on, which is noisy, where the safety or not depends upon how long it's going to go on for, how long the employees have worked or will work in such an environment, and also whether they're particularly susceptible. And all those things are outside the normal run-of-the-mill of safety concerns, which is to prevent immediate accidents arising from obstructions and slippery floors and that sort of thing.
My Lord, one can see the logic of that, but that would appear to us to be not right, because any of the exposure cases involve some temporal component, and it can't be that safety is confined to instant moments, whereas health deals with continuous processes. We know from the case of Davies that Section 5, a breach of Section 5 on lighting can apply to an instantaneous trip or a momentary trip. But likewise, in Section 30, for example, dangerous fumes and lack of oxygen, presumably there's a temporal component there before the worker is overcome by the fumes and the lack of oxygen. And in our respect,
they are a risk to everyone at the time who is in the room. And the oddity of the present situation is we're talking about something which is not actually a risk to anyone when they go into the room, or indeed unless they're there for a continuous period every day for a very long period.
well, those that will be injured will be in a small minority, but the same could be said of the hole in the floor. Not everybody's going to fall into it. It may only be one person, but the fact that only a small percentage is even exposed to the risk, because the others might not ever come into the room, is in our submission not a logical distinction to make.
Would it be safe premises be safe in a case where the occupier's method of working was to engage employees for a very short time?
So that the exposure to injurious sound
Yes.
was absolutely minimal, and no damage even to the hair follicles was likely to occur. In those circumstances, we would say that it probably should be regarded as safe. But of course, one doesn't know with the exposed workforce. We did an artificial exercise with a population of Mrs. Bakers yesterday, but one doesn't know with an exposed workforce how much exposure the workers have already had, and therefore only slight exposure may be sufficient to trigger further injury. But the standards that have been laid down in subsequent regulations, of course, impose a much greater burden than we're seeking to impose, because they haven't got a temporal limit other than the 8-hour day. So if you subject a worker to an excess of 85 decibels for an 8-hour day, then it doesn't matter if that worker's never going to work in noise again and has never worked in noise prior to that day. There'll still be a breach, even though could be no conceivable injury to the particular employee, whereas here I accept there has to be. The employer, looking at it prospectively, must have an anticipation of sufficient years to cause injury. But it's not going to know, in respect of the workers, how much exposure they've already had. Lord, in our written case at paragraphs 46 to 76, we set out our submissions on place of work and cite much or authority, which I won't now repeat. Yesterday you were taken to the Robins Commission where it refers to noise, and your Lordships will recall, that's Authorities, Volume 12, Tab 17, and your Lordships will recall that paragraph 344 there referred to the first case on deafness in December of 1971. That case, we know, was Berry and Stone Manganese, which your Lordships have in Volume 1, Tab 12, and in that case, at page 188, the claimant did rely on the forerunner of Section 29. The defendant conceded that on the current state of the authorities, he couldn't argue that Section 29 or its forerunner didn't apply, but he reserved his argument for the higher courts. The matter was never pursued. The only relevance of that is that it does appear that had Lord Robins' committee read the judgment in that case, they would have been aware that Section 29 even then was being, or its equivalent, was being raised as an available argument in a noise-induced hearing loss case. Lord, we've made our point about treating a place of work simply as a place. The words say place, the section is directed to the safety of the person being in that place for the purpose of his work. And we say that the section is plainly not confined to the fabric of the workplace. Reference was made yesterday to the case of Evans and Sant, Lord Chief Justice Widgery. That's Volume 3, Tab 44, at pages 635H to 636A. Lord Widgery himself would have allowed the section to apply to activities carried on which are constant, regular and recurring. And the same in our submission is found in the case of Bowman, the case from Northern Ireland, which is volume 8. Which I've misplaced for a moment. Thanks very much.
Well, I think you've given us very full references to the various views, maximum, minimum and middle way. Indeed.
Well, we've amplified the river of cases, my lord. I had in mind Mr. Justice Carswell, as he then was, in Bowman, volume 8, tab 24, paragraph 96, where he makes a contrast. He says, I'm conscious in expressing these views, questioning the decisions of a number of judges sitting at first instance, should be reluctant to decline to follow them without firm reasons, consider that one could, while accepting their conclusions as correct, distinguish those decisions on the ground that in order to make the place of work unsafe, danger has to come from something which makes the place itself dangerous. If the sound of a caulking machine creates noise of a level liable to damage the hearing, that is a state of affairs which exists in the locality, as long as the machine is in operation, and any person who comes within range is in danger, which appears to us to be parallel to Lord Chief Justice Widgery's reasoning, could be on this basis that said that the place is dangerous during the production of the noise. Where a caulker commences on a task which involves operating his caulking hammer, a piece of metal, however, the danger of physical harm from the vibration comes from that operation and is limited to himself. It is created solely by the machine which he brought there. The place is no more dangerous to anyone else than it was before he arrived there and commenced caulking. So we don't agree with the second part of the example, but we respectfully suggest that the first part supports our thesis that...
Well, it doesn't, does it? I mean, he doesn't agree with it, actually. If you read the previous bit of his judgment, what he says is he questions whether all the previous cases are right, but since there are a lot of first instance cases, he'd be reluctant to decline them to follow them without firm reasons. And then he goes on to say that.
Exactly.
I don't think it's going to be very helpful to examine large numbers of first instance decisions.
No. Lord, well, that was the last one on the point. And Lord, we say place of work is conditioned by the worker working there. We refer to the Oxford English Dictionary definition. I won't take your lordships to. It's volume 11 at tab 25. We particularly draw attention to page 939 and wrote the definition at Roman 4, which is position or situation with reference to its occupation or occupant. In our respectful submission, workplace or place of work really only has a meaning at all by reference to what is happening at the place. And we draw attention to section 175(7) of the Factories Act.
Which paragraph? Are you referring to a paragraph in your case?
I'm not, Lord. So, the page reference that I just gave you, Lordship, was in the extract of the Oxford English Dictionary, which one of the appellants put before your Lordships at volume 11, tab 25, so page 939. And the heading is Big Roman 4, position or situation with reference to its occupation or occupant.
What's your point on section 1775?
Well, if I could just find it, volume 10 again at tab 13. It's section 1757. Where your lordships find that premises shall not be excluded from the definition of a factory by reason only that they are open-air premises. So it would be curious indeed if it were right that section 29 was confined, as the appellants say, to the structure and fabric of a building if it can apply to an open place where relevant work is being carried on. Lord, I've already dealt in passing with the provision of ear defenders, which we say could make the place safe for the person working there, even if the noise is not rendered harmless, to use words of another section. And we say that using the ordinary and natural meaning of the words, it would be absurd if the employers could say, well, the place was unsafe because of the loudness of the noise, but we are not required even to provide ear defenders to satisfy section 29. Lord, so far as keeping safe is concerned, I think we've already said that we accept that it's not a question of risk-free, and we adopt respectfully the material risk provision which is found in the Shargo case, Authorities, Volume 6, Tab 95, Paragraph 27. Well, so far as a minority of workers is concerned, the argument is that a place can be safe if it only affects a minority of workers. We respectfully reject that. That can't be right, because there are many dangers to which only an individual may succumb.
When you say you adopt the definition of material, I mean, Lord Hope's definition was the law doesn't aim to create an environment that's entirely risk-free. It concerns itself with risks that are material. It's directed at situations where there's a material risk to health or safety, which any reasonable person would appreciate and take steps to guard against. Are you adopting the whole of that test?
Yeah, well, it depends. The looking at it to see if it's safe, of course, can be done with hindsight. We're certainly not accepting that has to be done with foresight. But we accept retrospectively that if a risk is shown not to be material.
But that's what's troubling me. I mean, if you accept those words, it seems to me that they make sense if the question is whether a reasonable person would appreciate and take steps to guard against it before it materialised. But you say you only look at that retrospectively.
Well, there are two stages here in determining whether a place of work is safe or not. That can be done retrospectively. If a place is unsafe, it's unsafe, and that's my Lord Justice Dyson's point about the tobacco smoke. It was always unsafe. Looking at the second part of the equation, reasonable practicability, it may be different. It may be that has to be looked at prospectively, and if it can be said, well, nobody would have appreciated that this was a risk. Or at the time there were no precautions which could be taken, that may be an answer, even though there are precautions available today. But in determining whether a place is safe, we say that should be looked at, as is now known, after the man has had the accident, after the incident has occurred.
Are you going to deal with the case of close in relation to reasonable foreseeability?
Lord, I wasn't specifically going to come to it, but Your Lordship having raised it, I probably ought to.
Well, I raise it because I can't remember which of your colleagues, when I think I asked on day one, which was the best authority, referred to the House of Lords case of Close. And it did seem to me that it was a case that you had to deal with.
Well,
are you in a position to deal with it?
It's a case under Section 14 of the Factories Act, and it's not the rationale is similar to the other Section 14 cases. In our respectful submission, the answer to it is that the parallel should not be drawn. And what I was going to do was take Your Lordship to the case of the Northern Ireland case of Mains and Uniroyal, Scottish case I should say, Mains and Uniroyal, which draws the distinction. Lord, we've dealt with this in our written submission, although not referring specifically to Close. Can I just find the passage?
Well, the distinction is that Section 14 is absolute, whereas Section 29 is qualified by as far as reasonable and practical.
Yes, and that dangerous is not necessarily an antonym for safe.
Yeah.
Well, there's Mains and Uniroyal we deal with in paragraph 95 of our written case. And the passage to which we draw attention, this is in volume 8 at tab 15. So sorry, Lord, I can't find the passage. Can I just take a moment? Yes, my lords, it's at the foot of at the foot of page 535. Just below letter H. Perhaps I should pick it up at letter E. And this is this and Lana are the two cases where reasonable foreseeability in relation to Section 29 have really been argued out. At letter E, he says, in the first place, in my opinion, court faced with divergence of authority in both England and Scotland on the essential question which can't be properly reconciled. Despite the valiant attempts of counsel on both sides, ratio of Morrow, direct conflict with that of Robertson and that of Lana with Taylor, while the English authorities not binding on us, consider where Scottish authorities conflict, title of Pick, and so on. In the second place, I think it's self-evident that where Parliament legislates in a specific area, such as the protection of workmen, in terms which do not make express reference to reasonable care, the intention is to heighten the obligation on the employer from that imposed by the common law to give greater protection to workmen. Authority for this can reasonably be derived from John Summers' speech of Lord Simons, while I would not elevate the proposition to a presumption, this is my view in aid to construction. Third place, nothing incongruous about Parliament imposing strict or absolute obligations on employers in relation to protection of their workmen. Numerous examples in many statutes Fourthly, turning to the Factories Act itself, I do not consider that it's appropriate to equiparate Section 14 with Section 29, with particular reference to the line of authority construing the word dangerous in Section 14. In my opinion, that issue arises under that section in order to determine the scope of the section in the particular instance, and indeed whether it applies at all, whether rightly or wrongly, according to the fact that the courts have interpreted dangerous under reference to reasonable foreseeability does not mean that necessarily the same criteria should apply when considering a different provision raising the questions of safety, particularly where that latter provision is qualified by a so-called escape clause, viz. Reasonable practicability, and Section 14, when it comes to breach, is absolute. I don't consider that it's appropriate to apply the law which limits or determines the scope of Section 14 before considering a breach of it to what constitutes a breach of Section 29(1) under reference to safety or lack of it. I therefore consider that Section 29(1) stands on its own, and authorities relating to Section 14 fall to be ignored. If there's anything in the point that it's unfortunate for two different tests to apply to two sections which might apply to the same set of facts, I'd venture the view in passing that there may be at least a question as to whether, when Parliament legislated in relation to dangerous machinery, it really also intended that issue to be covered by a general section relating to the place of work. However, since parties are agreed in this case that Section 29 applies, I don't shrink from applying a different test from Section 14 simply for that reason. While as a matter of English language, safe may be the converse of dangerous, in my opinion, Section 29 has to stand on its own and be construed as such. That I will now proceed to do. And then His Lordship construes Section 29 in a way with which we respectfully agree. And I suppose it's really the next paragraph that is...
But could Section 29 be applied in every case of a bit of machinery flying off, where the claim would fail under Section 14? So the answer to cases like Close would be now that the case would be brought under Section 29.
Yes,
that's the effect of your argument.
Yes, although, as your lordships have seen, there's a divergence of authority because Lord Diplock, Mr. Justice Diplock, as he then was in Taylor and Coley oils.
Then Lord Justice.
Sorry?
Is then Lord Justice.
I'm so sorry. It was then Lord Justice in Taylor and Coley oils. It came to a conclusion that would have said that Section 29 wouldn't have applied because Section 14 did not, whereas clearly Mains and Lana would have come to the converse view, in our respectful view. So, as your lordships, our case that Lana.
Your submission so far has been that you can choose, or at least the claimant or the prosecutor can choose which of these sections to rely upon.
Well, they rely. Normally, the practice is to plead all of them. Of course, anything that's remotely likely to succeed is pleaded. That's the practice, and in some cases, such as Ross, 3 sections succeeded.
I must say, speaking for myself, I understand the point about the fact that Section 14 doesn't have the reasonable practicability defence in it.
Yes.
But just looking at the language, meaning of the words, dangerous on the one hand and safe on the other. I mean, surely Lord Justice Diplock was right to say that the one is an antonym of the other. I mean, how do you argue against that?
I mean, clearly that has great force, but that's not necessarily the answer to the question. The point, and I think what Lord Johnson is making in the Mains case, is that the restrictive interpretation in Section 14 should be applied only to Section 14 and doesn't apply to Section 29. And Section 29 should, in our respectful submission, be construed broadly and not be constrained by the approach that was taken by the House of Lords in Close and the other Section 14 cases. I mean, Close and those cases has, of course, been subjected to some academic criticism in that it's said that is not the proper approach to a statutory provision which was intended to protect workers from machines. But
Do we have that academic criticism?
We don't, Lord. We don't. But it's the law, I mean, clearly, but it's confined to Section 14 in our respectful submission.
Well, I think it might be of some assistance if we could be given the reference to the academic materials. If you could send us a note as to what the academic materials is, that would be helpful. But it is a bit difficult, because if you look at Section 14, subsection 2, says insofar as the safety of the dangerous part, ... So it's a bit difficult to say that both sections 29 and sections 14 are not focusing on what's safe and what isn't safe.
I accept that, Lord.
Indeed, in subsection 1, it seems that safe is clearly used as an antonym of dangerous, because
Yes.
every dangerous part, unless it's in such a position as to be safe as it would be if securely fenced. That can't mean a higher standard than the opposite of dangerous in the first part.
Lord, I see that...
I suppose safe, though, in that section must be, well, I don't know, absolutely safe.
At any rate, Lords, it's clearly a matter for your Lordship, but our submission is that your Lordships are not bound by the construction of Section 14 to apply the same logic to Section 29. And it may be ultimately that the distinctions are ones of policy rather than statutory construction. But those cases are confined to Section 14 with one exception of Taylor, which makes the cross-application.
Coming then to Section 29, which way does policy point? Because you have the qualification twice, so far as is reasonably practicable, which suggests a moderate or acceptable standard. Doesn't that, I'm not sure how far you interpret that as covering any problem that there might be perceived to be, or whether you seek to restrict that as the Court of Appeal did. But whether or not, even if its ambit is narrow, might that not be taken as suggesting that safe should also be read in a reasonable, in the way it would reasonably be understood at the time?
Well, my Lord, we say not, because otherwise one has the difficulty which was referred to by Lord Justice Denning in a minority judgment in the Court of Appeal cited by learned friends. If I can just turn it up, it's in my note here. It's a case called Burns and Joseph Terry. I just wonder if I could show your Lordships the way Lord Justice Denning, as he then was, approached it. This is Authorities Volume 2 at tab 20. And at 466, he says, I can take it from the top of the page, applying this test, the wire mesh clearly insufficient, but it only barricaded the wheel, this is a grinding wheel, from a frontal approach, not from the flanks, which left wide open, any employee could put his hand or arm through them and reach the wheel. I wish I could end my judgment there, for it's really all that's necessary, but I must go on, because it's said that in considering whether a machine is securely fenced, the court must consider whether the action of the employee getting caught by it could be foreseen. I can't see what that has to do with it. It seems to me that foreseeability only arises at the next stage, if and when it's said that the occupier, by the occupier, that the machine was in such a position or of such construction as to be safe as it would if securely fenced. Primarily, obligation on the occupiers to see that the machine is securely fenced. Once the prosecution proves absence of fencing, then if the occupier relies on the exception as safe as it would be if securely fenced, burden is on him to prove it. Test of the exception is foreseeability. You can foresee the possibility of a man moving into contact with machinery when unfenced, clearly not as safe as if securely fenced. But if you can't foresee anybody coming into contact with it, it's as safe as if securely fenced. Good illustration in Carroll's case. And then picking up the paragraph below, once foreseeability is accepted as the test of the exception, it can't also be the test of primary obligation. Subsection 1 of section 13 enjoins the court to make a comparison between machinery which is unfenced and the same machinery as it would be if it was securely fenced. You can only make that comparison by first visualising an effective barricade in position and then asking yourself whether the machinery is as safe as if the barricade was there. If you should seek to make the comparison by asking what could be foreseen, you get nowhere, because foreseeability would be both the test of securely fenced and also the test of as safe as if securely fenced, so that no comparison would be made possible. View which I have expressed is strongly supported by section 15, which shows that when considering whether machinery is as safe as if securely fenced, you consider the persons who might move into contact with it. That is, you consider foreseeability, but there is no such provision in seeing whether it is securely fenced. So, Lord, we say the same logic would apply here. Lord, can I...
So why would the same logic apply here?
Because if reasonable foreseeability applies to the first element, whether the place is safe, then it shouldn't apply to the reasonable practicability as well.
Maybe it doesn't.
To my mind, it doesn't.
Is it you support the Court of Appeal on this? Do you say that reasonable foreseeability comes in at the reasonable practicability stage?
Yes, to the extent that it comes in at all, yes, Lord, and not at the safe stage.
Well, it may be that I mean, obviously one wants to get it right, but in practical terms, apart from the fact that the burden of proof is different at that stage, in practical terms, is there any difference?
Well, yes, there is, my Lord, because one. I'm sorry, I'm not fully understanding the Lordship's question.
No,
Whether
if reasonable foreseeability, you accept that you can't just say in section 29, well, there was a risk. It doesn't matter whether an employer couldn't reasonably have discovered that there was that risk. There was the risk. It did eventuate. There was damage. Therefore, liability. You're not contending for that extreme position, as I understand it.
No.
You say, however, that the way to, as it were, avoid that extreme position and to take account of reasonable foreseeability of risk is not at the first stage, but at the second stage. And what I'm putting to you is apart from the fact that the second stage shifts the burden to the defendant, what difference does it make? What difference does it make whether you're at the first stage or the second stage substantively?
If the evidence is that the employer couldn't conceivably have known of the risk, well, then the result would be the same, whether one applied that at the first or the second stage. That must be the case, I think.
Well, you say couldn't conceivably. I mean, that's putting it very high. But anyway, if I've understood you correctly, you are accepting that the position is the same whether, if reasonable foreseeability, whether it comes in at the first stage or the second stage, the only difference is onus of proof.
Yes. We have to accept that reasonable foresight plays a part in this, but the only place we say that it can come in at is at the reasonable practicability stage. Your Lordship poses the question as to whether that actually makes any difference, whether it's at the first or the second stage. I wonder if I could deal with that or Mr. Huckle can deal with that at 2 o'clock, Lord. Can I just think about that proposition, make sure that I'm not...
Could I suggest you one possible
yes.
construction of this section, assuming that reasonable foreseeability at the moment does come in at a stage, it makes more sense to introduce it at the first stage and ask whether it's reasonably foreseeable that the system is safe, or I suppose unsafe. Then at the second stage, the defence may be much more narrow. It's all about, as Lady Justice Smith says, it's all about the means of curing the unsafety once you've established what it is. And if one looks at Lord Upjohn and Lord, I can't remember who it was, Pearson was it, or Pierce, in the Nimmo case, that's how they formulate the test. They formulated it in a narrow way, and to my mind, the cases which have considered of Section 40 of the 1974 Act do the same. So what the defence is, it focuses on something which is unsafe.
Yes.
And once you've discovered that your system is unsafe, then you must put in place reasonably practicable means, and that's what reasonably practical means.
Yes.
So that's the meaning rather than reasonably practicable has.
Yes.
And it's got nothing whatever to do with reasonable foreseeability of the risk in the first place.
Yes.
You could go further and say that nevertheless, safe means safe, as Lord Justice Peter Gibson held.
Yes.
But that may be a step too far, because perhaps for the reasons that Lord Denning gives in Close, where he says that there are no indications. Everybody, was that passage about everybody who's been practicing the common law for the last 100 years knows that sort of thing.
Lord,
I'm also interested in what's meant by reasonably foreseeable in this context, again by reference to what Lord Denning says in Close.
That seems to me the key question, whether you regard it as coming under safe or reasonably practicable. Is one simply talking about reasonable foresight as a limited concept, or does it include reasonable appreciation that this is a risk which is not acceptable?
yes, yes. Well, Lords, I'm grateful for the way your Lordships put it. Can I just reflect on that over the short adjournment and come back with our...
I'm not suggesting anybody else sees it in the way I see it.
No, absolutely not. No, I understand, of course. Lords, can I just take your Lordships to the other authorities on which we place great reliance? And the first of them, of course, is the case of Lana, which is in volume 4 at tab 66. Lord, it's essentially the judgment of Mr. Justice Peter Gibson, as he then was. Lord Justice Hurst's views are much the same at pages 559 to 560. Mr. Justice Gibson at page 561 deals with section 29 at letter H. He says, first, does the word safe in section 29(1) of the Act of 1961 mean safe from a reasonably foreseeable danger, so that a workman injured at his place of work by an accident which the employer couldn't reasonably foresee is unable to succeed in a claim for breach of statutory duty? Secondly, if so, on the facts of this case, was the danger reasonably foreseeable? Start by considering the words of section 29 partner authority. They contain no express reference to foreseeability, reasonable or otherwise. Safe is an ordinary English word. Can't see any reason why the question whether a place of work is safe should not be decided purely as a question of fact without putting any gloss on it. See Monkman. Further, to imply words in the section so as to introduce a test of reasonable foreseeability is to reduce the protection afforded by the Act for the workman. The plain object of the section being to provide for a safe working place, NIMO. On principle and on authority, that is permissible. See John Summers. Impermissible, forgive me, Viscount Simons. That is not unfair. that is not unfair on the employer, whose duty to make and keep the working place safe is qualified by so far as is reasonably practicable. See no necessity to imply any other qualification. It would also seem wrong to me to imply a requirement of foreseeability, as the result will frequently be to limit success in a claim for breach of statutory duty to circumstances where the workman will also succeed in a parallel claim for negligence. Thus it reduces the utility of the section. Williams accepted no authority to compel us to conclude that Section 29 refers to such a testimony, refers to Robertson and so on.
That's a bit the tail wagging the dog, isn't it? I mean, this is a criminal provision. The civil, it was designed to raise standards, not to create civil liability, although that's followed.
Indeed, but my Lord, the civil liability is attached to breach of this legislation since, on the authority of the House of Lords, since 1898, Groves and Lord Wimborne. And these acts have always, from that date onwards, imported civil liability. So it's not really the tail wagging the...
On the basis it's implicit in the statute?
Sorry?
On the basis that it was implicit in the statute?
Yes, or that the statute was designed for the protection of a specified class of person, namely workers, and therefore under Cutler and Wandsworth Stadium and those other cases, there could be a claim for damages for breach of the provisions. So in making the legislation 1961...
It does seem a slightly odd way to construe a penal statute then, to say that it would be more useful civilly if you're held to have committed an offence.
Well, my Lord, even the House, and I'll show you a case later, has accepted that that is a factor in the construction of these statutes. Can I come to that in a moment? So, my Lord, at letter F, quotation is made to the section 14 cases, Lord Reid in John Summers, adopting Walker and Bletchley Flettons, your lordships know the reasoning there. These comments on the meaning of dangerous in that provision, which contain no qualification of reasonable practicability, have surprisingly been relied on in obiter comments on the meaning of its antonym safe in section 29 of the Act and other similar provisions, notwithstanding that they do contain such a qualification. In Taylor, Lord Justice Diplock, and giving the judgment of the court, say the occupier's duty, and your lordships have seen that quotation. He referred to the passage which I've referred from Lord Reid's speech in John Summers. The Taylor case was decided before Nimmo, and that approach to section 29 needs reconsideration in the light of what was said in Nimmo. Thus, in Nimmo, Lord Guest said, to treat the onus as being on the pursuer seems to equiparate the duty under the statute with the duty under the common law, namely to take such steps as reasonably practical to keep the working place safe. Can't think the section was intended to place such a limited obligation on employers. In any event, comments to this course in Taylor were obiter. In Keenan, Lord Migdale said duty on the employers to take steps as far as reasonably practical to safeguard the workman against all causes of injury. 4 months later in Robertson, my view, test of reasonably foreseeable doesn't apply to a section like section 29.1, which already embodies the qualification of reasonable practicability, so as to put on the pursuer an obligation to show that the event should have been foreseen. However, in Morrow, distinguished Robertson and applied the test of reasonably foreseeable. And at G, I recognise the importance of construing statutory provisions applicable both sides of the border in a consistent fashion, but in the present state of the authority, it seems to me we're free to choose whether to apply test of reasonable foreseeability. For my part, for the reason I've already given, prefer to read this section without implying any such test. Lords, we set out in our skeleton, and can I take your lordships now, our written case, I should say, these arguments starting at paragraph, or picking up paragraph 92, which is the citation from Lana, and then Mains we refer to at paragraph 95, and some of the other authorities in the cases that follows. My lords, it will be an inexcusable waste of a few minutes left to me to take your lordship to all those. But can I just show you lordships the House of Lords authorities which we start with at our paragraph 110, beginning with Austin Rover. And your Lordships know the speech of Lord Goff. This is Austin Rover, Volume 1, Tab 7, and the speech of Lord Goff is at 62425, which I'm afraid we've rather tediously set out verbatim for your Lordships. But in that speech, Lord Goff did refer to the close case. Can I just take a moment to find the reference?
Well, at 624,
I'm grateful to your
first
Lordship.
main paragraph.
Yes. So, Lord Goff, in the passage which we've cited, which runs from 624D to 625D, had in mind close, of course, and the case of Allen, which my learned friends refer to. Lord Jaunce's speech at the end also appears to us to be material. If your Lordships have page 635F, your Lordships will have seen the passage to which my learned friends have referred just above at F. When a person makes available premises for use by another, reasonableness of the measures which he requires to take to ensure the safety of those premises must be determined in the light of his knowledge, the anticipated use for which the premises have been made available, extent of his control and knowledge of any of the actual use. Premises are not reasonably foreseeable cause of danger to anybody acting in a way which a human being may be reasonably expected to act in. Circumstances in which a human being may reasonably be expected to act in circumstances which may reasonably be expected to occur during the carrying out of the work or the use of the plant or substance, purpose of which the premises were made available, I think it would not be reasonable to require an individual to take further measures against unknown and unexpected events. And then over the page, he says, at the top of the page, I would stress that in the middle words, reasonable relates to the person and not to the measures. The question is not whether there are measures which themselves are reasonable, which could be taken to ensure safety in the absence of risk to health, but whether it's reasonable for a person in the position of the accused to take measures with these aims. The emphasis is on the position of the accused. Thus, while only one yardstick determines whether premises are safe at any one time, the measures to ensure the safety required of each person having a degree of control may vary. Approaching the matter in this way, content may be given to the word so far as is reasonably practicable. It could, having regard for its degree of control and knowledge of likely use, be reasonable for an individual to take measure to ensure the safety of premises, but it might not be reasonably practicable for him to do so in regard to low risk, high cost. And Lord, the words which had to be construed are in section 4 of the Health and Safety at Work Act. It's set out at 623 at letter F. It's section 4.2 and subsection 2 embodied in the middle of that indented paragraph reads, it shall be the duty of each person who has to any extent control of premises to which this section applies, or of the means of access thereto or egress therefrom, or of any plant or substance in such premises, to take such measures as it is reasonable for a person in his position to take to ensure, so far as is reasonably practicable, that the premises, all means of access thereto, and so forth, are safe and without risks to health. So in that section there are two requirements of reasonableness: reasonable practicability as to the measures, and reasonableness of taking them for the person in the position of the defendant. And that may explain at least partly what Lord Chauncey said at 635. Lord, in going back to our submissions, we also refer and rely on the case of Shargo, and again, tediously we've set out the quotation, and I shan't take your lordship to the authority. It's volume 6, tab 95, and it's paragraph 17 to 21. And we say that that's equally consistent with Rob and Salamis as well. And then we've referred to some other cases which fall on the other side.
So when Lord Hooper says it's a results-based, what does he mean by that?
Lord, we think it means that if the employer's duty is to guard against the result that occurred in the particular case, so that if somebody is injured, that demonstrates that the place wasn't safe.
Now, how does that fit with his Lord Hope's proposition in the other case we were looking at?
Of material risk.
Yeah.
Yeah.
It's the same case.
Oh, it's the same case, sorry. Well, so, how does that paragraph then fit in with
Paragraph 27.
paragraph 27? Because it did strike me there's a tension between those two. And one way of looking at section 2 and section 3 is to say they are results-based.
Yes.
The employers must ensure that the employee is not exposed to it. The undertaking is not conducted in such a way as to expose the employee to risk.
Yes. Well, I think the resolution of the tension can only be that it's permissible to look retrospectively to see whether there was...
Is there any discussion of this in Lord Roban's report? Because presumably it was this act which flowed from Lord Roban's report.
It was.
So is there no discussion of... I mean, the whole idea of this report, of Lord Roban's report, was to produce less of a mishmash and more of a coherent
Yes.
statement of principle.
Yes.
And so one might have thought there would be some discussion of this very point.
Well,
Is there no discussion whatever in Roban's report about this?
We couldn't find any, and I take it that Mr. Deloff couldn't either.
Right, okay, thank you. So how does that fit in, his paragraph 17 fit in with what I gather is paragraph 27?
Well, Lord, then I think we have to say the only way that it can fit in is that results-based is a retrospective look to see whether it was safe or not. And that's the only way that it can fit in with the material risk.
Well, this case, Shargo, is interesting because it does actually look at the criminal law aspect and asks the reason why paragraph 27 arises is under the head proportionality, I think, in connection with the European Convention on Human Rights, whether this is a proportionate construction of a penal provision.
Indeed, Lord.
You're going to refer to some case where it had been said that wasn't, or at least another approach had been also said to be relevant, looking at the civil scope of liability that followed.
Yes.
Perhaps you would refer to
Yes,
at some point in your...
Yeah, indeed, my Lord. Indeed.
But just going back to paragraph 27, you say that paragraph 27 is consistent, do you, with looking at these questions retrospectively?
Yes.
That wouldn't be very proportionate, would it? I mean, if you do import human rights thinking into this area, you would assume that what was proportionate was to be judged at the time when the person was supposed to be taking precautions.
But if he's immune from liability under the rubric reasonable practicability, then it is proportionate because that affords him a defence.
Indeed, my Lord. But the point is not developed beyond those very few sentences.
But it is difficult to see how the events, his conclusion in the quotation that you in the early paragraph
21.
17.
Maybe the solution is the one my Lord suggested, Lord Kerr, that this is actually embracing the whole of the statute, and he is reading reasonably practical in a wide sense.
Yes. Well, Lord, I'm very conscious of the time, and can I leave this as part of section 29 by making one reference to Horton and Taplin, which I think I learned from Mr. Lim relied on, certainly in his written case. Horton and Taplin is a case where foreseeability was held to be an element. It's Authorities, Volume 3 at tab 56. But we make 2 points about it. One is that the cases where foreseeability was held not to be an element in assessing safe were not before the court in that case. And secondly, my only friend, Mr. Lim, says that Horton was approved by the House of Lords in Robb and Salamis, but that approval was quite limited. My Lord, it's Volume 6, tab 100. This was a ladder which should have been clamped to the bunks in the sleeping quarters on an oil rig and was not. Lord Hope deals with Horton and Taplin at paragraph 23. At D, where he says, as Mr. Justice Bodie said in Horton, a step is only realistically necessary when the mischief to be guarded against can be reasonably foreseen. And Lord Clyde deals with it at paragraph 46, where he says, page 190, letter D, the origin of Regulation 20 appears to be Rule 2.6 of the Annex to the Work Equipment Directive. Provision uses the word necessary, and that word's been carried forward into the regulations. Present case proceeded on the basis word imports a requirement for reasonable foreseeability. Reference made to Horton and Taplin. I should wish to reserve my opinion on the precise meaning which is appropriate the word as used in the directive, bearing in mind that its purpose, albeit in laying down minimum safety and health requirements, is nevertheless to achieve improvements. So that the approval given by the House to Horton is, in our respectful submission, limited. And of course that was on a different regulation, the 1998 Work Equipment Regulations. My Lord Mance asks for the authority that we had in mind in relation to criminal sanctions. My Lord, it's a case called Harrison and the National Coal Board, which is in the green volume of... Sorry? It's in the Respondent's Supplementary Bundle, which is a thin white one, my Lord, with shiny covers, at tab 6. And it's a short passage. This dealt with the Coal Mines Act of 1911. I think my Lord in the chair has the green
the wrong one,
volume,
yes.
not the white one. There's a slim white one with a ring binder, which it comes from my learned friends, and one that looks like that, which comes from us.
I don't appear to have got yours. Very simple. Yes, you're quite right. Sorry. It's, yeah, yes. Right, yes.
Lord, it's tab 6, Harrison and the National
Yes.
Coal Board, if your Lord.
Thank you. Sorry about that.
Grateful. Lord, it's a passage at page 650. And it's the third paragraph on the page, where he says, before, however, one analyses the relevant wording, it's necessary to consider the proper approach to the matter. It was suggested on behalf of the respondents that the Coal Mines Act 1911 is a measure imposing criminal liability, therefore should be interpreted as throwing no greater burden on the employer than its words compel. It has, however, to be remembered that the Act is also a remedial measure passed for the protection of workmen and must therefore be read so as to effect its object so far as the wording fairly and reasonably permits. Lord, that was adopted by Lord Justice Denning, as he then was, in relation to the Factories Acts, in a case called McCarthy and Coldair, which is in Authorities Volume 5, tab 75, at page 1227 to 8, 1227 to 8.
Thank you.
Lord, we've made submissions about the other legislation. Here, can I make some quick points about the various regulations which have been referred to in, of course, my learned friends' submissions. First of all, the Offices, Shops and Railway Premises Act 1963, Volume 10, tab 11. They point that provision is made in Section 21 for regulations for both noise and vibration. We point out that there is no equivalent to Section 29 in that Act. There is no provision for making and keeping a place of work safe. Then the woodworking regulations of 1974, made under the Factories Act, Volume 10, tab 23. We say this is a typical piece of piecemeal legislation in the field of health and safety at work. Regulation 44 is an add-on to the rest of the set of regulations, which is about protecting from other injuries, particularly guarding of machinery and so on. But Regulation 44 requires reduction to the lowest level reasonably practicable and for ear protectors. We found no case where that provision has ever been applied. So the lowest level reasonably practical under Regulation 44 could in fact apply below the 90 dBA LEPD level. The tractor cabs regulations of 1974, made under the Health and Safety at Work Act, are Volume 9 at tab 1. Regulation 3.3 specifies a limit of 90 dBA, but not 90 dBA LEPD. So, and given that tractor cabs will usually be used intermittently or for less than 8 hours a day, in those cases, the limit will not be reached. The noise at work regulations of 1989, which are volume 10, tab 15. Have they
Sorry, just going back to clause 44 of the woodworking regulations. Your case would involve the proposition, wouldn't it, that it is likely, to put it at its lowest, that any woodworking factory which had managed to reduce noise to 90 dBA would nevertheless be guilty of a criminal offence under section 29.
Yes, and possibly under section 44 as well, because or where somebody is likely to be exposed to a sound level greater than 90 dBA for 8 hours, then the measures that have to be taken are not to reduce it to 90, but to reduce it to the greatest extent which is reasonably practicable, and ear protectors should be provided and made readily available.
Yes, I follow that. So that, but the same argument would apply, wouldn't it, to a woodworking factory where the sound level was less than 90 dBA?
Yes, on our argument, section 29 would impose a higher standard. I accept that. Lord.
Why was clause 44 of the regulations necessary?
Lord,
if it imposes a lower standard than an existing statute?
Well, my Lord, it does, but this is an example of a situation where the legislation is simply overlapping. These provisions, as your Lordship sees, section 44 is very much an add-on right at the very end of extensive regulations about machinery, which it might be said, some of which is unnecessary in the light of section 14, although some of it is plainly or said to be in substitution of section 14. Now, clearly, I accept that those who drafted it didn't appreciate that section 29 might have had the effect that a reduction to 90 was not all that was necessary in order to protect workers. But that, in our submission, is not conclusive evidence that section 29 was not intended to and did not have the effect of protecting workers at lower levels, where those risks, as it happens...
Bit hard though, isn't it, on a woodworking manufacturer who looks at the regulations, is told what he must do in clause 44, to be told, well, despite these regulations in 1974, they don't go anywhere near far enough, and you have committed a criminal offence under another act, albeit you have satisfied the provisions of clause 44. Seems a bit hard on him, doesn't it?
Lord, no more hard than the cotton mill next door, to which section 29 does apply and the woodworking regulations do not.
But the long and the short of it, put it another way, is that clause 44 of these regulations is totally unnecessary.
Well, my Lord, the effect of our submission is that section 29, in some cases, can impose a higher standard. Where it imposes a higher standard, this regulation would be unnecessary, yes.
The answer to my question is yes, it's, on your submission, yes. It's unnecessary.
Yes. Can I just take a moment, Lord? Yes, Mr. Huckle makes the point, of course, that this provision is not results based. This will apply whether or not anybody is injured. So to that extent, it applies a higher standard.
Sorry, say well, section 29.
Well, not if section 29 is results-based, my lord.
So you had to help me on what you mean by results based.
You can't mean you can only have a prosecution if someone under section 29 if someone gets injured.
No, that must be right, my lord.
That's been held in under the 1974 Act.
Yeah.
Shall we resume at 2 o'clock? How are you doing? You're going to leave enough time for the appellants?
Yes.
Are you?
We will, my lord.
We're assuming an hour and a half. Is that what your lordship had also?
That was certainly, I think, what we were assuming, yes.
Yes.